Thank you so much, Adrienne, and thank you so much, everyone, for being here today. My name is Nora Gallo. I use she, her pronouns. I am Lily's co-executive director of the Every Voice Coalition and a 2020 grad from UMass Amherst. I'll pass it over to Lily.
Hi, everyone. My name is Lily James. I use she, her pronouns, and I'm Nora's co-executive director for the Every Voice Coalition. I graduated about 2 weeks ago from Mount Holyoke College back down in South Hadley, and I'm really happy to be with all of you here today. And I'll turn it over to Danielle.
Hi, everyone. My name is Danielle St. Pierre. I use they, them pronouns, and I am the Massachusetts State Director for the Every Voice Coalition. I'm going to pass it to Lindy.
Hi, everyone. My name is Lindy Aldrich. I may have met some of you in the past as the Deputy Director at the Victim Rights Law Center. I started my own consulting business about a year ago called Ladder Consulting, and I'm excited to be here with you today. I'll pass it to Katya.
Hi, everyone. My name is Katya Santiago Taylor. I use she, hers, and ella en español. And I am also the policy director at the Boston Area Rape Crisis Center. So I'm so happy to be here with you all. And I'll pass it to Hema. Yep.
Good morning, everybody. My name is Hema Saring-Saminsky. I use she and they pronouns, and I am the policy director at Jane Doe Inc., the Massachusetts Coalition Against Sexual and Domestic Violence. And I will pass it to Adrienne.
Hi, everyone. Good morning. Adrienne Ramchin. I use she, her, hers, and I am the policy coordinator at JDI. And I will start sharing my screen now for the presentation that we'll be doing this morning.
Excellent. So welcome all. This is our inaugural town hall for sexual and domestic violence providers, specifically to talk about this incredible new law in Massachusetts. There has been a great deal of hard work put into the passage of this law, and largely through the efforts of Every Voice Coalition and this incredible team of folks who have come together to really ensure that survivors of campus sexual assault have the protections and options they need, and that we move towards prevention of sexual and domestic violence on campuses. We know that the details of this law, even though we've talked so much about the excitement of the passage of this law, are still probably fairly unknown to many of you. And so we wanted to bring all of you here together today to really dive into the nitty-gritty of what does this law do? What are the responsibilities of institutions? How do those responsibilities intersect with your work and your programming with survivors every day? What are components that create new opportunities and possibilities for outreach and engagement with campus survivors? And really here to answer any questions you all might have about both the implementation process and the future of what this law means for providers and survivors in Massachusetts. So with that, I will turn it over to Adrienne, and just want to keep in mind to gather your questions. This is an initial conversation. We will always create space to talk about any questions or concerns that all of you have throughout this process. Thanks, Adrienne.
Thanks, Hema. So I'm just going to give a little bit of background context on this bill. Many of you are probably familiar with this bill. It took 6 years to pass in the legislature, and finally, at the end of the last legislative session, it passed the House and Senate. And then in January 2021, just earlier this year, Governor Baker signed this bill into law. And so now it's referred to as Massachusetts Chapter 337, or colloquially, you can just call it the Campus Safety Bill or Campus Safety Law, now that it's actually signed in. And really what this law does is that it establishes protections and resources for survivors of campus sexual assault at colleges and universities in Massachusetts. And it's really important to keep in mind that this law does apply to all colleges and universities in Massachusetts, so both public and private institutions. This law is set to take effect on August 1st of this year. So we're just a couple of months away from when this law is going to take effect. And we really wanted to bring all of you together today, as Hema said, to sort of dive into a little bit of the nitty-gritty of what this law entails. There are several required actions that institutions of higher ed are required to take, but as SDV providers, it really kind of calls on all of you to play an important part in this work. Many of you might already be located near colleges and universities serving campus survivors already. But one particular piece of this law that calls out and really names local community-based DPH-funded SDV programs is a requirement that institutions enter into MOUs, memorandums of understanding, with both a local rape crisis center as well as with a local domestic violence service provider. And so some of you may have already had reach out from your local universities or colleges. Some of you might have that coming down the line. So that's one particular piece that we really want to talk with you a little about, and recognize that folks might have questions on what exactly an MOU means, what that might look like. And so we'll talk a little bit about that today, along with just familiarizing everyone with all the different components that this law requires, because it will impact any student survivors that you all are working with. And before I think I'm handing it back over to Hema to sort of go over the 5 sort of key provisions of what the law is, just want to give a shout out to Every Voice Coalition and all of their hard work that they did to really get this bill off of the ground all these years ago. I think when I look at this campus safety bill, I see the power of what it means for an impacted group of people to advocate for and to really fight for what they need and what they think they deserve. It's a long fight. It took 6 years to get here, but we did it and we're finally here. And I think I can speak for JDI and Lindy and Katya at BARCC that we're so happy and proud to have been able to work together and to work with EVC to get this bill passed into law. So it's been a long time coming, and we're excited to finally be at this point where we can be having this conversation about what this means for campus survivors now. So Hema, I will pass it back over to you.
Excellent. So I have the easy job of laying out the 5 components before I turn it over to Lindy and others to dive far more deeply into each of these components. But as a quick map of what we are talking about today, we're going to start with this on this slide is an overview of requirements for Massachusetts institutions. And we will talk throughout this and think throughout this conversation about the ways in which this intersects with your work as providers. The first is creating institutional policies and required training on sexual assault and DV on campuses. The second is a sexual misconduct climate survey and information sharing about that survey, because the realities of what campus sexual assault looks like are often hidden, and this is an opportunity to bring light into the experiences of survivors on campuses for all students. The third is creating a new role called a confidential resource provider. And we're going to talk in a lot more depth about what that means and what that does and how that differs from what folks might be familiar with as a Title IX officer. The fourth is a memorandum of understanding with sexual and domestic violence providers, and as Adrienne had mentioned. And the fifth is prevention and awareness programming, because we do see this as part of a continuum of prevention work. So those are the bullet points of this law, and just deep gratitude for all of you for being here and for the incredible teamwork that went into the passage of this law, and really want to lift up Adrienne's shout outs to the power of student organizing. And with that, I'll turn it over to Lindy.
Hi, everyone. I don't know if I can turn the slide. There we go. It's wonderful to be with you today. Thank you so much for joining us. I also want to echo everyone's thoughts about the Every Voice Coalition. It has been a joy, frankly, for the last 6 years to work with them and to continue to work with them, because I believe so strongly in what this bill can do and what their mission is. So again, I wanted to mirror those comments. So I'm going to talk a little bit about what the varying policy requirements are that come out of this bill. For those of you who are familiar with Title IX and the Clery Act, you're going to see a lot that you'll remember or that you'll recognize. So let's start with institutional policy on sexual misconduct. Institutions must have a trauma-informed policy. It must be available on their website no later than August 20th of each year. And it has to be updated regularly. It also needs to be made available anywhere that students gather. So think of libraries, dining halls, dorms. There's all kinds of things that, places that each campus will uniquely have where students gather. So it needs to be, easily accessible. And it needs to include a lot of particular pieces, things like how to report, what their disciplinary procedures are, national, state, and local resources, as well as what's on the campus, local law enforcement, emergency services, and medical assistance. So there are a lot of different things that the policy has to include. I feel strongly that many Massachusetts campuses already have this information, but this bill essentially codifies the fact that it must always include these elements. All right. One piece that's not listed here is that both internal and external entities, such as the district attorney, local law enforcement, have the ability to look at the policy and make comments on it. So I think that's an important piece that you also be aware of as an advocate. And for those schools within your county or within your area, to keep a close eye on their policies so that, if you have comments and hopefully you're being included, that you can also participate in changes and revisions. So speaking of law enforcement, this bill also requires that institutions enter into an MOU with local law enforcement. And that if they don't already have one, it must include policies and procedures of how they will work together and what each party's role is in prevention and response to incidents of sexual misconduct. I know we've been talking about sexual violence, domestic violence, but I also want to mention that stalking is included in this bill, and as well as, I believe, gender-based harassment. So just, know that it's broad and that all kinds of behavior is going to be included in both the policies and the MOUs. And all of state and local police department members who would respond to or be a first responder to an incident of sexual misconduct must be trained in awareness to sexual violence and trauma-informed response. One thing I wanted to point out on this slide in particular is opportunities, I think, that local community providers can work with institutions, if you aren't already, to provide training. And I know that Hema is going to talk a little bit later about MOUs specifically with your agency, but I wanted to point this out as an opportunity to get paid, I think, in some ways, to provide these types of training. So this is one piece with law enforcement that I think is a possibility for that. Secondly, another opportunity for community providers is that there needs to be training for individuals involved in the disciplinary process. So anyone who's involved in that process must be trained or experienced in handling sexual misconduct complaints. So these are folks like Title IX coordinators, members of campus police or campus safety. They have to be aware of the stereotypes and the perpetration methods, as well as how to respond in a trauma-informed way. And that these trainings must be annual for anyone who's conducting investigations, hearings, and other proceedings. So there's another opportunity for smaller schools or schools that have not been as actively training their teams to engage with, I think, local community providers if you feel that, you could offer trainings like this, and something to think about when HAMA goes through the MOUs. All right, so I'm going to hand it over to Katya.
Hi, thank thank you. All righty. So I really can't start without talking and giving again power to every voice. I joined the efforts to pass this bill about 3 years ago, maybe. And I honestly don't think that the bill or the law would have passed if it wasn't for the students. They drove this work. They reached out when they needed support, but they were at the State House. They were consistently pushing it. And it talks a lot, it shows a lot about the power of people's voices and students' voices. It was an amazing experience working with the Every Voice of the students. And I also want to recognize that when I talk, I often mention or focus on sexual violence, but like everyone has said, this bill is this law is for domestic sexual violence, harassment, gender-based. It's for all inclusive. So if I catch myself, I'll correct myself, but I want to make sure that we recognize that the students that we're working with face many different harms done to them, sexual violence being one of them. So one of the most amazing things that I think are part of the law is the amnesty policy and the anonymous reporting. And what do we mean by amnesty policies? We mean that we want to make sure that survivors of sexual domestic violence who want to report an incident, they will be protected themselves. We know, or at least I know, that many students, college age, engage in behavior that might be considered inappropriate for higher ed institutions, like drinking alcohol or violations of drug policies or violations of student conduct. And students who are sexually assaulted or experience harm are afraid of reporting what happened to them just because of what happened to them. And if we add the pressure of the behavior that they were sort of engaging when it happened, then it will cause more fear, it will cause more harm. And some people may choose not to report in case that they will be harmed by reporting, or they experience they will be charged with a violation from the higher ed institution for the actions that they were taking. For example, during COVID, we knew that many colleges and higher ed institutions were saying to the students that if they were caught socializing during COVID quarantine, they could face expulsion. And what would that mean for domestic and sexual violence or harm done to a survivor? So that would have meant that if they went out and they were sexually assaulted because they went on a date or they gathered with a small group of people and they were sexually assaulted in that moment, there was the fear that if they went and reported, they could have been face expulsion because they were socializing during quarantine. So the amnesty policy, what it gives is the student the protection that they're not going to be face retaliation for any behavior that they may engage, and they were harmed at that process. And the goal is to reduce fear among students so they can report if they choose to report. The second option is the anonymous reporting. And again, I find this a really empowering policy because we know, statistically speaking, many survivors of sexual violence and domestic violence choose not to report the harm done to them because of fear of retaliation, because of fear of not being believed, because of fear of just coming out. When we work with higher ed students or students who are in higher ed, There's also students that are trying to figure out where they're going to go, what they're going to accomplish. They might be afraid that if the person who's causing harm is a teacher or someone in a position of power, they're not sure. So by providing the option of anonymous reporting, we give them a break to figure out, to be able to report the incident, but to figure out what path they're going to take for their healing, what is it that they want to do, how are they going to take care of themselves, and then maybe hopefully be ready to come out not anonymously. But the anonymous reporting gives them that space that they can present and report the harm that was done, but it doesn't mean that they have to make it announce it to everyone that it was them. From the institution side, I think this is going to be really helpful because it also gives the institution a space to whether gather information, gather data, gather evidence that they might need, but not necessarily forcing the student to come out and report that it was them. So I hope this was helpful. And then there's going to be some options to do a lot of questions in a little bit. So in the meantime, I am going to pass it to Lily.
Awesome. Thank you, Katya, and thank you everyone as well. So the next section is the Sexual Misconduct Climate Survey. So this really comes out of a need for more data on regarding what is happening on campuses. There currently is really a lack of both data collection, so we don't really know the scope of the issue, where it's happening, what we really need to know in order to better prevent it and better meet the needs of students and survivors. So this is really where this climate survey comes in. So in the law itself, there is the creation of a task force who is responsible for designing the sexual misconduct climate survey that institutions must conduct every 4 years. So that task force is responsible for creating that base set of questions. And that task force is comprised of really a diverse group of stakeholders from various different perspectives, including four of whom are representatives of providers. So really making sure that there's representation of expertise in that area. And I will also mention that there is many student voices on that task force as well, which is very important. So what that task force does is creates the base set of survey questions that institutions will use, and also can create recommendations regarding timing, application, how to implement the climate survey in the best way possible. From that base set of survey questions, institutions do have the ability to add further questions as they deem necessary or as it would be helpful on their campuses. That task force is set to begin shortly, although there's no specific date. And the first base set of questions will be delivered no later than January 1st, 2022. So that's really going to be happening over the next few months, looking towards January when that can then start being implemented on campuses. The second part of this is that the data that has been collected from those surveys is not something that institutions, are keeping private or by any means. It is something that is required to be shared publicly. So institutions must post a summary of the results of the climate survey within 120 days of completing the survey. And that, really ensures transparency from institutions to make sure that they're accountable for what's happening on their campuses, as well as generally creates more transparency for students to know, prospective students to know what's happening on campuses, and for everybody to be able to know sort of what's really happening on campuses in a way that's not currently available. In addition to posting the summary of the results, some of this is already required, and as Lindy mentioned earlier, is just codifying it in MA law. law, but a copy of annual security reports from the Clery Act, contact information for local and or state or national 24-hour hotlines to provide information on sexual misconduct, contact information for Title IX coordinator on campus, and relevant Title IX policies and reporting options. And then the contact information for the confidential resource provider, which we'll talk more about in a second, and descriptions of those confidential resource provider services. And then finally, the name and location for the nearest SANE exam and what kind of transportation is available. So by posting all of this on the website, this will hopefully create a lot more transparency and a lot more, readily available information for student survivors who are looking at their options and don't have to then go sort of digging through websites or have to do a lot of work on their own on this. And then finally, there also is a requirement that there is a submission of relevant statistics related to what's happening on campus regarding sexual misconduct to the DHE annually, no later than December 1st. So generally, there's a lot more information sharing, a lot more transparency on what's happening on campuses, as well as making sure that student survivors are able to access that information as necessary. And I'll turn it over to Lindy.
Hi, everybody. I'm back. So let's talk about something that I think has a lot of connection to your work that you're doing at various community providers around the state. This particular resource provider is a position I feel very strongly about and have been advocating for my entire 15 years of career, my 15-year career in the law. It is essentially forcing institutions to designate at least one confidential resource provider on their campus. And in Massachusetts, these positions exist, but not at every school. We have 133 institutions in Massachusetts, and while many of them do have it, I can definitely count some folks that don't have them at all. So it's an important new area for students that are at the schools that have never had a confidential resource provider. So I'm really excited about this. I think that schools would be better served if they worked with their community provider to help this position have as many resources as possible, because ultimately what we're trying to do is create extra resources, lots of options, and lots of awareness about what survivors on campus can access. So let's start from the top. The confidential resource provider would not be obligated to report to the Title IX coordinator. They would serve as what I like to call the confidential bubble for students. They advise students on the different options for reporting on and off campus, resources such as mental health, rape crisis, medical, law enforcement, all of the different resources that are available, as well as providing support on campus to help aid in changes in class, changes in living, transportation, accommodations for their job, or their athletic team, or their scholarship. So there's lots of things that they will be doing. So it's a great kind of resource for students on campus to get help between what's offered off campus and what's on campus. So I noticed that somebody had a question. So what's the difference between a CRP and a CRA? That is my fault. I should have fixed that. In Massachusetts, they asked, it was one of the final changes, they asked that the name be changed from confidential resource provider to, from confidential resource advisor, to confidential resource provider. So sorry, I should have changed all of those A's to P's, my apologies. In New Hampshire, where this bill was also passed, it is called a CRA. So the CRAs must receive training in both trauma-informed response as well as sexual assault awareness and prevention. And they have to show that they've had an ability to provide support. So they'll have to have had some kind of training. They will also coordinate on and off campus rape and domestic violence crisis center resources. So there's a lot there that they will be responsible for. Basically helping navigate the on-campus needs of a survivor, as well as referring to and having relationships with off-campus providers as well. One of the things I'm most excited about is that CRPs will have statutory privilege. It's extremely similar to what rape crisis advocates and domestic violence advocates currently have. And this protection will mean that their records cannot be accessed in the event that there's any litigation. Obviously, there's a potential that a judge could order those records, but it is a much more complex process now than it has ever been for campus advocates. So I'm really excited about this last piece. All right, so I'm gonna hand this over to Katya, and I will say I'm happy to also discuss with you all later at some point the different models that we're seeing with schools and how they are staffing this particular CRP position. Might be better once we open it up to everyone.
Thank you, Lindy. So I want to do a quick explanation of the MOUs, and I can imagine that this is where we're going to have a lot of questions. So I want to leave some room for questions and answer, as this might be more specific. But so the bottom line is that institutions are required to have memorandum understandings with local rape crisis or domestic violence centers if they don't meet the requirement of having a confidential resource provider. And the goal is for the rape crisis or DV program to help them develop sexual misconduct policies, help them develop prevention and awareness programming, provide training regarding the sexual misconduct, and then again provide the resources for students or employees of campus. So what we know is that, like Lindy was mentioning, higher ed institutions are all over the spectrum. We have some higher ed institutions that have really solid, comprehensive programs. Aside from Title IX, they have advocates in place. They have really strong policies. They train. They have 24-hour hotline. They have all of this. And then we have institutions that have nothing. So when the law was created, it was to sort of to make sure that we can hold all of the institutions accountable to some sort of bigger minimum at least. And then you can always go above and beyond. But the goal is to make sure that survivors, regardless of the higher institution they go to, they have specific protections. We also understand that some higher ed institutions have this tendency to lean into protecting their institution and might not be fully focused on protecting the survivor or making sure that any survivor in their institution has access to all of the resources that they truly need to lead a healthy life. So it's sort of they're more leaning to protecting their institution. So we just, again, want to make sure that if any survivor or any person in an institution facing some harm done to them, there's some bottom line protections. So one of the things that is really important is to know is that you, as the domestic and sexual violence program, you're in the driver's seat, right? You are the people that know how to protect the survivor the best. We know that. We know that you as an institution have most, if not all of the tools that you need to make sure that you really focus on the survivor and now no one else. So now is our time to shine. We can sort of lead this effort to make sure that they have access to the services that we know how to provide best. And we just have to be really careful because we don't want the higher ed institution to try to take advantage of us as a provider. They know how to teach, they know how to provide higher ed programming. we know how to support domestic and sexual violence survivors. So when we establish the MOUs, we want to make sure that we, as our providers of DVNSA, make sure that we add what we need to add, that survivors is center, like the survivors' rights, survivors' resources are center in the agreement. So that's sort of like a really quick description of why the MOUs were established. And I want to leave we'll have time at the end to go into really specific questions of what you can have and what you shouldn't. But I will end by making sure that, again, DVNSA programs, we are the experts in supporting survivors. And we just have to make sure that we can add and make sure that we can be on the driver's seat of making sure that the sexual misconduct policies have a survivor center focus. The programming is primary prevention and awareness, because we want to end sexual and domestic violence, and that whenever we try to engage in providing support to survivors, all of the information remains confidential and protected to make sure that survivors can really access everything that they truly need to access for their path to healing. So I will pass it. I am really bad with this. Lily, again, thank you.
Hello. It's actually going to go to me, Nora. Hello, everyone. So I'm going to speak about the prevention and awareness programming. So just to put this in context with the other slides that you've seen about the components of this statute, a lot of those components are really centered on who is experiencing sexual violence and what can we do to support survivors and students as they navigate college post-incident of sexual violence. But something that we also need to definitely focus on is how do we prevent this violence from happening in the first place? So under this component of the new law in Massachusetts, all colleges and universities must provide a mandatory annual sexual misconduct primary prevention and awareness programming for all students and employees within their 45 days of either students' enrollment coming to the university, or for those who are being hired by the university, 45 days from the start of their employment. So what will this programming include? So really being able to give them an explanation of what are their civil rights, what are the civil rights laws relevant to sex and gender-based harm. Being able to empower people with the knowledge of what their rights are is incredibly important so that they understand what happens if this does end up happening to me. If I'm coming in as a freshman, what do I have access to and what can I do after this happens, if it does. But again, we really want to prevent that from happening. So an explanation and training about consent, how drugs and alcohol use can impact an individual's ability to give it consent. So really being able to sort of weave consent education into these trainings, because that's something that a lot of students may not be coming in with awareness or education around. They may have never talked about it. And there may be students who are coming in with a great amount of education, but what this does is offer sort of for all students to have baseline education around consent. And then also being able to empower students and employees with information on what their reporting options are, including how they can sort of go through an anonymous disclosure if they don't want to come forward and include sort of their name or information about themselves when they're reporting. And then also if they do want to sort of go through an official report through the institution, local law enforcement, that there is information about the institution's procedures for addressing these reports of sexual misconduct and what the penalties would be if somebody was found responsible for an incident. So again, that goes to really empowering people with the knowledge of what are our options, what can we do? And then also information on the confidential resource provider and how to contact them. And then again, in line with the explanation of consent and consent education, and how drugs and alcohol can impact one's ability to give consent. Strategies for bystander intervention. If this is a conversation that we're having on our campus, we are able to be empowered with the skills and tools to be able to intervene in a situation where harm may be caused. And then to also, if we're being taught by bystander intervention, we can also sort of understand and be aware of what the signs of gender-based harm or sexual harm can be, so that we can recognize if it's something that is occurring to ourselves. So that's that on that. And I do want to say, as Katia was saying before, that this is a process that community service providers can collaborate with their institutions on in the development of this programming and these trainings. As she said, you all are experts in this field, and that is knowledge and information that students and also employees at universities should be empowered with. Just to wrap this up before I pass it back on to either Adrienne or Hema, this training really is going to ensure that everyone within a campus community is aware of what their available resources are, and ways to also keep their campus community safe. So that's it. Thank you so much, and I'll pass it back to one of those two.
Oh, sorry about that. After a year, I still struggle finding my unmute button. So I just want to close this out with a couple of next steps. So we will be doing a very similar presentation for institutions of higher ed, where we'll be going through this presentation and really walking them through what their responsibilities are in this law, and going through those same 5 requirements that this law requires institutions to begin implementing in August. And so we'll be doing that as a recorded video that will go out to all of the institutions and colleges and universities in Massachusetts. Our hope is to also do sort of like a part 2 workshop for SDV providers, really taking another opportunity to all come together and talk about what it looks like and what it means to serve campus survivors, and what maybe go into a little bit more of what that MOU might look like. Some of you might already have existing MOUs with a local college or university. Would love to hear from folks about what that looks like, maybe an opportunity really for information sharing and peer-to-peer learning about what it looks like and means to work with campus survivors. And then in September or sometime later this fall, we're hoping to have another call where we can bring everyone together, bring together institutions of higher ed along with local community-based SDV providers to help facilitate some of those relationships, really for the purpose of not just the MOU, but for building those hopefully long-standing relationships between colleges and universities and their local RCCs and DV programs. I think Katja mentioned, and I think Lindy, we've all mentioned at some point today that there are some universities who are great and have really great trainings and policies around addressing campus sexual violence. Some programs, some universities might have their own sexual assault response units, but every college and university is different. And so we want to make sure that we're able to help facilitate this relationship building for you and for the local colleges and universities. So those are a couple next steps for folks to keep an eye out for. I'm sure we'll be sending notices in the next couple of months or so about some of these dates. But this is the end of our formal presentation. Thank you all so much for attending. And I know I've already seen a couple of questions come up in the chat. And so we're going to open it up for a Q&A now. I don't know if Danielle or Hema, I know you've been collecting some questions, if there are ones you want to share with us first, or if we want to just open it up to the whole group.
I think it would be great to talk about the question that came in about wondering if schools can designate a team to serve the function as the CRP position, because folks think it might be, too much for one folk. So Lindy, I know that you responded. Do you want to take the lead on that?
Absolutely. So I didn't want to jump too far into all the details of what the CRP position holds, because it changes for so many different institutions. So it was a great question. I really appreciate it. It is my interpretation of this bill that schools that already have existing programs with a number of different advocates within them would essentially designate those advocates as CRPs so that they could gain the privilege. Because I think the hope is that anyone who's currently working in those positions would continue to do the fantastic work that they're doing, fill in any gaps that may have not been under their kind of umbrella, but then now gain the privilege to protect their records. So yes, if there's a team, my hope would be that the team would all be designated so that they all could receive the privilege. One important piece that I didn't mention on the slide that I did is for schools that are smaller, the bill designates that if you have less than 1,000 students, you can share a CRP position with another institution. I think this is another fantastic opportunity for community providers to really help find the right person who could share this responsibility between schools. You all know the institutions that are within your service area better than me. You know the different unique characteristics they have and what type of advocate might make the most sense with their populations. I think this is an opportunity that community providers could reach out to schools and help them to designate the right person or help them even find the right person. Perhaps that person is within your staff or someone on campus who would fill that position best. And it's another opportunity, I think, to have a better relationship as well as potentially bring in some revenue to the community provider. So something to think about, but there are lots of different structures that they can use. So going from large urban schools or large state schools that already have existing programs to say community colleges that frankly don't have really this position right now, who would need help but are large, to really small schools that might need to share a position. So just something to think about. There's lots of different ways that they can go about structuring it, but I'm happy to continue talking about those structures too.
Another question that popped in chat is, can you clarify the scope of the confidentiality of the CRPs?
Well, the scope would essentially be similar to what rape crisis advocates and DV advocates currently have. Any communications, and that can be written, can be notes that are taken in, a current system. A lot of schools use Maxient, for those who are familiar with that, but it's really any communications that are written in your files or any verbal communications that you have would be protected in the event of litigation. I believe it's the same absolute privilege that rape crisis and domestic violence advocates have currently. So there are ways to pierce that privilege, but it generally requires a court order. So it's a lot more protected than just having, general kind of privacy protections. That is what advocates currently have.
And just to jump into the sort of ending part of that question regarding helping, reporting party, do changes, et cetera. The law stipulates that a confidential resource provider shall not disclose any sort of confidential prior written consent of the reporting party who share the information, but it's not that they can't do it. It's just really ensuring that there is, consent of whoever is asking for that before that information is shared.
Another question is, how does a service provider become a designated CRP?
That is a question I don't think we can quite answer just yet. It's a great question though. These different structures are going to take time to create, and we're going to run into challenges, I'm sure of it. What I'm hoping is that we can create some intersections between institutions and community providers, and institutions that are lost will hopefully ask for help, and we can start to create those designations. There also is going to have to be a training component of these advocates on campus. So that's another place for intersection. So I'm hopeful that, as the months with the task force and as, we move forward, we're going to be able to create some structure that we can build around how those are designated that everyone feels comfortable with. But I don't have the answer right now, but I just know that we are working on it. We are thinking about it.
We'll definitely note that and definitely get back to that question when we have the answer for that. Another question is the CRP supposed to be available for the person coming forward or the respondent, or both?
Go ahead, Lily.
I can go ahead if it's okay.
Both. Oh yeah, go ahead, Nora.
I was just going to say, the law stipulates that it's for students generally, and so it is for both either respondent or complainant, but also to sort of clarify that this position is really to be able to what I like to call ICE, inform students of what their rights and options are, students or employees, connect students to available resources and supportive measures, and then also explain what their options may be and what the impact of those may be. So it's for any parties, but it's also for students who are not going through a reporting process.
Thank you. Next question is, can you please clarify, do schools have to have an MOU with an RCC and a DV program, or is it either or? And secondly, if a DV program partnership is required, do we have to be funded by DPH, or might some other criteria be considered?
I'm happy to start kind of fielding that based on a conversation we had earlier. I believe you have to have an MOU with both. So you need to either have an MOU with an organization that does both services, but you cannot just have a rape crisis MOU and not have one with a DV agency. So again, it's going to be very specific to your area, right? And what resources are available and within the service area of that institution, whether it's one MOU or two. The question of whether you have to be DPH funded is a good one. And we know that that has become an issue, I think, in some areas. I think this is something we're going to have to bring up to DPH and continue that conversation about the services of the non-DPH funded agency and whether or not that's going to meet the criteria that the bill requires. So I think that's an unfortunate, I don't know, again, and more time is going to be taken to figure out that answer, but it's a good one. And I'm so glad that folks are raising it now so we can start thinking about it. And folks, feel free to jump in if you have other thoughts on that.
Thank you, Lindy. And the next question is, does this change Title IX accessibility to go back to including off-campus offenses? And will any templates of MOU or training tools be provided?
So wait, read that to me back again, Danielle. What's the first part?
Sure. Does this change Title IX accessibility to go back to including off-campus offenses?
Oh, I love that. No. Schools under the current regulations, schools have the discretion to provide, a violation can occur off campus. It just has to be a separate process. It cannot be considered under Title IX. My own personal opinion, and I don't speak for anyone else, is that I think that the current administration is going to make a change to that, and it's going to be coming, where we're going to pull those off-campus offenses back under the umbrella, but it's not covered in this particular bill. And we would have to have a lot more time to explain why it wasn't. Believe me, we fought hard on this. So Nora, if you want to jump in, that's my answer to that.
I just want to follow up. Yeah, thank you, Lindy. That was a perfect explanation on that. No, it will not change the scope of Title IX, but what it will do is really be able to provide resources and supportive measures for survivors, regardless of whether they are looking to file a report. So, thinking of in a context of, if a student is off campus when they experience sexual violence And, that's not within the scope of Title IX, so they cannot file a Title IX report through their institution. What they're able to do is still go to their institution to be able to sort of seek resources and supportive measures, whether that is through the MOU, CRP, et cetera, so that receiving school-based supportive measures is not contingent upon filing a report, especially if a student cannot.
Thank you, Nora and Lindy again. And the second part to that question is, will any templates of MOU or training tools be provided?
This is Hema. I'm going to jump into that question. I think that is the hope, right, of a gathering like this, and that follow-up town hall and conversation that Adrian had mentioned as well. What we would love to hear from all of you are about, MOUs that have worked really well, lessons learned in cultivating partnerships with colleges and universities. This is an incredible opportunity to deepen relationships with campuses for those who already have those relationships, and to foster new relationships for those who haven't previously. We would hope that as a collective, we're able to offer some guiding principles, FAQs, model templates like you had mentioned. I think that would be a incredible goal of our collective work together. And we need your support also in that. So if there are models, templates, you all are experts in this work, and we would love to hear from you, and feel free to reach out to, any of us on this presentation. We'll make sure you have our contact info. At least where one of us or one of us work or are at any given moment. So we would look forward to hearing from you on that.
Thank you. And I don't see any other questions in the chat, so I'm not sure if any other folks have any questions that we can answer. All right, so we do have another question. If the CPR is meant to is also to be resourced for the alleged perpetrator, is that only if the person asks for help, or will this be proactively provided to them?
It's my understanding that it would not be a proactive reach out. I mean, as part of just kind of a client empowerment model, I believe that, it's about communicating to the campus about the resources that are available and having folks reach out affirmatively. I've often kind of shied away sometimes from having folks reach out and reach out and reach out. So and I mean more on the survivor end of things. So I definitely feel that it would not be a proactive reach out to, frankly, either party. Nora and Lily, I can't remember, is there anything in the bill that says that, unlike New Hampshire, where it kind of cuts off the communication once one party has reached out? I was curious if you remember that part. I'm thinking of New Hampshire, I think. Yes,
thanks, Lindy. There is a requirement that the CRP can only provide services to one party in, a case, if there are multiple, if more than two also. So, whoever is seeking help from them first.
There's also another question in the chat, but I'm not sure if I got the original question, but it's asking about younger than 18 survivors.
I think that's a great question. And I think that last name is familiar. Just going to throw that out there. I just want to say, it's my understanding that the term for student is going to encompass your under 18-year-old students. So in terms of the bill, I think the bill is going to encompass anyone who identifies as a student. So clearly you could have, say, a community college who has a student that's in high school, but also taking classes at a community college. And as long as they fall within that student umbrella, I think they're going to be able to access the CRP's resources. One thing that's interesting that's not in the bill, as far as I'm aware, is that there may be mandatory reporting requirements under Mass law. I think everyone who's on this call is probably familiar with those because they are required to report. So it may need to be included as a part of the CRP's training to ensure that they understand under 18 survivors that come to them, they're probably going to be required to report under those laws as well.
I know that we had another question in the chat. So Megan originally asked or stated that that could create a big problem for LGBTQ plus survivors. Will there be training on assessments? And then clarified and said an abusive partner could go to the CRP first, cutting off access to the person being abused.
I think that is the CRPs are required to have training, extensive training. So I think in the implementation conversations, certainly, I think in the same way that we talk about the importance of screening across the board, I think that would need to be a integral part of the training that's offered, since that's such a common dynamic that can happen.
I'm also wondering, and again, this is for more resourced institutions, if they might have access to CRPs that they could split by complainant and respondent. I don't know, I can't say that for schools that are really small, if that's going to be possible, but it's one way of potentially thinking about some of the larger schools who have more resources. They may be able to create a definitive office split so that we don't have that ability to cut people out of resources, but that's not going to work for everyone. I acknowledge that that's not going to work for everyone.
The next question says, what happens at NH schools when both the respondent and complainant seek services from the CRP, if the CRP is a single position?
I don't know if Lily and Nora have had any feedback yet. It's a new bill. They are just a few months ahead of us. I don't know if they have that feedback yet. Do you know, Nora?
Yeah, happy to answer your question, and the answer is no. So the law in New Hampshire did pass last summer of 2020, but we're still in the process of sort of going through implementation. So we don't have that yet, but I think we will be able to hopefully have more information on that in the future.
Is there any other questions that folks have? So the question is, can or should MOUs include payment for services, training, etc.?
I would say yes. I would say yes. Like, again, like I said earlier, us as the service providers, we are the experts on the service that we do. Higher institutions are for profit, so in one way or another, so they have different funding sources. So we deserve to be get paid for the work that we do, and we should be asking for it.
And I think for schools that have not been being paid or don't have a rigorous kind of revenue stream coming from institutions that they've been providing, trainings and things like that without payment, this is an opportunity to reconstruct that agreement and to say, we've set the playing field now that there's an expectation for payment. So I just want to throw that out there that, it's okay to re-examine past experiences or past trainings or things that you've provided and kind of relook at what the rest of the state is doing, and hopefully, might be a better revenue source.
So there was a comment about wanting to hear from other community service providers, are they going to ask for payment in regards to that? So I don't know if that's a conversation that we want to have right now, or is this going to go towards the part 2 workshop? So I'm going to leave that to folks up on the call.
I think we certainly have some time to workshop conversations like that here. So if folks want to, raise their hands and throw out your experiences with MOUs or offer to be a resource for the follow-up conversation, we'd love to hear from you.
I was also going to suggest to those folks who have specific population experience or expertise on staff, consider, having some kind of curriculum that you might be willing to sell to institutions so that, while they have, they'll have MOUs specifically with certain institutions, you could also potentially do a statewide training on specific population expertise. So that's something that's, I think, missing on many campuses, that, they aren't working with populations and understanding the impact that the crime has on that particular population, obstacles to reporting, things like that. And it's an expertise that many of you have on your staff. So just something to throw out there as you consider thinking about it. A lot of times institutions won't know to ask. So I think be proactive in saying, we have a lot of folks in this population that we know about and we work with. You can obviously refer them here, but if your staff needs training, we could train them for X cost.
Joanne is raising their hand. Do you want to share?
Hi, I just want to share a little bit of slightly relevant experience that makes this a really important question, and I think really important for people to think about. Chapter 260, when Chapter 260 passed and the requirement that healthcare providers get specific training on domestic and sexual violence, created a mechanism and opportunity for healthcare providers to partner with local domestic violence, both domestic and sexual violence programs. And right away, the question came up about payment, and it was, in many ways viewed as an opportunity, but it also very quickly became competitive. And there were people, individual people, organizations, private consultants that were kind of all creating and being approved as trainers, so I privately messaged Aaron. I said, I'm having Chapter 260 flashbacks. I think it would be great to either, if there's any way to develop some kind of a template, maybe for maybe that programs create together a template for what is a fair amount to reimburse a program for the different categories of services, maybe, or somebody mentioned, what is the person's salary? If it's for a person, maybe pay them the percentage of their salary. But I definitely want to maybe encourage people to avoid what might be, it's tension, and then it might be competing in a city. You're going to have how many institutions with a range of programs they might compete with or partner with. Is it going to be who offers us the lowest rate? So I'm just foreseeing potential. It's going to be a much bigger question than the one line question that was put out there. So just want to share my experience with that landscape.
One of the quick questions or reactions that I had to that, to you, and thank you so much, is doesn't DPH set a rate, an hourly rate? No, I thought DPH has some sort of rate for
I think if they're in terms of what these MOUs could look like, that's interesting.
Mm-hmm.
I think a question is, in a very timely question, is the extent to which these collaborations would or would not be governed by DPH rate setting provisions. That's a whole other conversation for another call altogether, just given some of the restrictions that programs face with respect to how the rates are set. That said, I think, there is we would need to look into some of the details on how, what these, how DPH and others might influence what rates get to be set in this. So that's a to be determined question, I think.
Thank you so much for sharing. And, as we navigate these, we will definitely, continue these conversations. Another question is so a RA, are they supposed to be trained like a CRP?
I'm so glad we jumped back to that one because it's haunting me. No, an RA is not considered a CRP. We're looking for a person to be designated who would have this role either as a standalone or shared in that position with other institutions, but not to be shared with other administrative responsibilities on campus. I think an RA would have significant conflict because of the fact that they're also under the Clery Act considered a what is it, a CSA, right? A campus security authority. So I just think there's would have some concerns about that very specific position being considered a CRP or confidential resource provider. So the idea is that they would be a person who could really act in that capacity alone.
Another question that was put in the chat that Hema did respond to is how detailed does the law get regarding, content for prevention training, and does it hone in on addressing male students in particular about consent, or is it a general education requirement? Is there any more clarification that folks need on that? I don't know, Hema, if you just want to go through it again or.
I'll turn to others actually, but my sense is that from the language itself, I mean, there is, some guidelines around prevention education and naming consent education, but it certainly would, I think collectively, I'm hoping that we are moving, away from a particularly, gender specific lens or approach to this work. So I think that is really going to be informed by the, collective outreach and intersections with, with these curricula, what that looks like. I think this is where providers can play a powerful role in, influencing and kind of bringing the perspectives of, as Lindy mentioned, working with culturally specific populations or, any particular, lens through which we need to be understanding sexual violence on campuses or dating violence on campuses. I think that's really the power of bringing the breadth of information and community-based experience to colleges and universities to, enliven some of that curriculum and learn from each other too. Not that it's just one way, but I think there's a lot of hope there. I think related to that, I got a private question just around, is there an opportunity to do some kind of collective shaping of what campus outreach might look like across Massachusetts, how programs can work together? I think that would be fantastic to create. While of course every program might have their own approaches and lenses, at the same time to be able to come together and share, what folks are doing, what are some of the core values in some of these outreach efforts. I think that would be an incredible success through these kinds of collaborations and going forward. I don't know what others might think about doing some of that collective outreach strategy building, really.
I think that would be great to do that. We would love to work with all of y'all to be able to come up with that. Another question is this any different for community colleges or schools with no housing?
I'm happy to jump in on that. No. Obviously, there's different needs for the CRP and the type of resources, but they would still have to have that position or I mean, I can't imagine I'm trying to think if any community colleges have less than 1,000 students, so they would have to have a designated position. So from the CRP lens, no, it would not be any different. And anyone else jump in around MOUs, but I believe that's still a requirement no matter whether they have housing or not.
Is there any other questions that we can answer?
Can I chime in with one thought? This is Elizabeth from Hawk. Going back to the fear about the 260 impact, that resonated with me too. And sometimes through really good policy, community programs still feel an onus. That's an unfunded kind of mandate that comes upon us. And so even if the good is there, it can still, we have to figure that out, right? So I think whatever could be done with a real dedication to a collective tools and things like that, because this is so valuable, but it is one more thing to do without additional funding. There's the potential, right? So just in terms of thinking of that without each of us trying to reinvent the wheel, if those of you who had a vision for this could play a role in helping shape that with more clarity in terms of where the rubber hits the road, that would be hugely helpful.
Absolutely. I think that a lot of these questions we can continue to work on in our second workshop. I know that we have a time ending at 11:30, so I just want to be respectful of all folks' times. And again, if any other questions come up in the meantime, feel free. We are going to send an email with our contact information. Feel free to reach out to any of us, and we're looking forward to working collectively to, once this bill gets put into place on August 1st.
Thanks, everyone. Thanks, Danielle. Thank you, everyone, for joining us this morning. I think just like Danielle said, all of us can drop our emails in the chat. We can also, once we send out an email with the recording, a copy of the slides, we can include a copy of the law as well, and we'll include all of our emails. So please send us questions that you have so that we can help collect all of those questions and make sure that the second time we all get together for our workshop, we'll call it, we can help address some more of those questions and be prepared to talk about things like the MOUs and payments and things like that. So thank you all so much for joining us, and have a great rest of your day. I want to open it up to the rest of my presenters if they have anything they want to add or say.
Thank you so much for coming. Really honored to be able to share this space with you all, and really, really looking forward, even post-grad, to what this is going to look like in Massachusetts into the future. And we wouldn't be able to do it without all of you. So thank you.
Thanks, everyone. And thank you to our interpreters and our captioner.